No, she did.
Hi, everyone. We're going to give people a few minutes to join here, and we'll try to get started in another minute or two.
Helen, what do you think about me going ahead and sharing my first slide?
I think that's great.
And can you see that?
Yes, I can see it. It looks like it's not in presenter mode yet, but I can see it.
Oh boy.
Or maybe if you hit start from beginning, it'll.
I did, yeah. I think this one covers the whole thing.
Oh, perfect. Okay, we'll give it just a little bit more here. It's just now 6:30. All right. Well, good evening, everyone. My name is Helen Thigpen. I'm an attorney in the Missoula area, and it's my pleasure to welcome you to another session of Citizens Law School, presented by the Law Related Education Committee in partnership with the State Bar of Montana. Each fall, this program brings together lawyers and judges from across Montana who generously share their time and expertise to help us better understand the law and how it impacts our daily lives. Our goal with Citizen Law School is to bridge the gap between the legal profession and the public and to make the law more accessible, promote civic engagement, and strengthen our communities through knowledge. Tonight's session continues that mission, and we're very fortunate to have with us Hertha Lund, who will share her insights on Montana property law, including information about easements and homeowners associations. Hertha is the founding attorney of Lund Law PLLC in Bozeman, Montana, and she has been advocating for property owners for more than 3 decades at the national, state, and local levels. After earning a BA in journalism from Temple University, Hertha covered national topics including the U.S. Supreme Court and Congress before turning to a career in law. Hertha earned her law degree from the University of Montana School of Law in Missoula and clerked for the Chief Judge of the U.S. Court of Federal Claims. Hertha's legal practice covers a wide range of property matters, from road and ditch easements to wind and solar leases, water rights, and eminent domain. Hertha has argued before Montana's state courts, federal courts, and the Ninth Circuit Court of Appeals. She also is a self-described property nerd. So we are thrilled to have Hertha available with us this evening and to share her insights with us. We welcome questions throughout the presentation this evening, and we'll try to keep things pretty relaxed and free-flowing. So please, if you have questions, go ahead and drop those into the chat, and I will let our presenter know when a question has been posted. And we just really appreciate everyone joining this evening and look forward to having you join another session next week if you're interested. In the meantime, Hertha, I'll turn it over to you.
Great. Thank you so much, Helen. And I'm so happy to be here. I just love, love, love talking about property rights. And I really think it is a foundation of much of what we do, certainly in the law and in policy. And so all the people who are here tonight, thank you for being here. A little bit about me. I grew up first around a ranch near Zortman, Montana, which is in the Missouri River Breaks. We moved from there when I was in first grade to Browning, and we lived in Browning for 6, 7 years, and then moved to Lewistown, which is where I graduated from. And we lost our ranch in the early 80s when land prices got caught upside down and we had too much money borrowed. So they come and loaded our cows and took them away. And what we did as a family was ranch. So that was really hard on me. And I had to learn how to shoe horses to help pay for going to college. So I was a blacksmith and a horseshoer. And while I was working doing that, I started writing about some of the issues impacting Montana, and people said you should be a writer. So I went back to and finished my degree. I went from pre-med, pre-vet, and got a degree in journalism at Temple in Philadelphia. And after that, I worked as a writer, and I ended up covering Congress and the United States Supreme Court on behalf of the United States, the Farm Bureau, American Farm Bureau Federation. And while I was doing that, I got sent to cover a Supreme Court case on takings, which is where the government tries to take property. And I liked it. I liked that case so much that I decided I was going to go to law school. And so I did. And I came back to Montana to go to law school. And while I went to law school, since I was broke, I worked most of the time. And I actually worked as a lobbyist for the Montana Farm Bureau for 2 sessions. Remember, we're every other year. So my first and third year of law school, I worked almost full time as a lobbyist and writing their newsletter. So I've done a lot of work in property rights and in policy. And, I've been working in the area for 30 years and had my own law firm, I think, since 2010, so 15 years. And, if you look a little bit and think about property, let's see if I can get there we go. John Adams, one of what we call the founding fathers of the United States, he said, the moment the idea is admitted into society that property is not as sacred as the laws of God, anarchy and tyranny commence. As you can see, he thought a lot about property rights. And a lot of our way we're set up in the United States is based on a property rights and an idea of how to incorporate that as a basic right. We know that property is important, but why? Why is it that important? To the founders, property was part of the dignity of the human person. So the founders were inspired by John Locke, an English philosopher who articulated the theory of property that the founders, created the Constitution and the Bill of Rights from. And Locke's second treatise on government talked about that all property rights come from self-ownership. You own your own body yourself. If you own your own body, then you own what it produces. The product of a person's labor is therefore the property of that person, and a person can appropriate land and natural resources by mixing his labor with it. So that's basically some of Locke's second treatise on government. Now, when Helen earlier said that I like questions, I really do like questions. So please, if you have one at any time, just, let her know, and I'll do my best to answer it. And I really love it. So the legal dictionary, first and foremost, I better tell you who that is. That's my big bear mystic. She's a Gypsy Shire cross. She's about 16 hands and 1,700 pounds. And that's where I guess I can't even think of her as property. I do take care of her, and I do love her. And but she is really important to me and what I do when I'm not working as a lawyer. So the nitty-gritty of defining property, it's the legal right to use, control, and dispose of something. You can think of it as being tangible or intangible. For instance, we have property rights I wrote a book. I have property rights in the book I wrote. We have property rights in music, the rights to art. So that is a type of property. And then you can think about it mostly, and that's the difference between tangible and intangible. Tangible are things, or like when you get I can't remember when you get it's a tip of my tongue. When you create something new, you get a patent. There we go. And so a patent is like an intangible property right. And then if you think about the land, though, and like something tangible like this cup with a picture of my other horse on it, that's tangible, and so is land. And then there's the intangible, like the patent or copyright. Then the things that are tangible are created into several different types, real and personal. Real property is land and water rights. Personal property is my car, a trailer, uh, my clothes, my shoes, a boom box. All of those are personal property, and anything that has to do with land or water. In Montana, not all states, but in Montana, water rights are considered a real property right. So when you think about land, you think about, the real property. And I guess right now, if you look here on this picture, how many types of property do you see here? I'll just give you a minute to think about it. First here, I'll go through that because it's not so easy for you to talk, reach out and say something. But right here, I think I see a power line. I would imagine that power line has an easement to be there. That's where my the mouse is, or the pointer is. Here we have a road. That's a road easement. Here we have potentially the water in Montana. We have you have until the high water mark as far as owning the beds. So there's all these different places, and the use of the water is owned by multiple people. It could be owned by the people who live here, or it could be owned by someone else who has a diversion point anywhere, on this stretch of stream. So that all of that is still real property rights. So real property is land, it's the minerals. Somewhere in here there could be a there could be a well, but there also could be oil and gas. So that's a different type of property right. So anything that's not part of what's real property is all the things we would call personal property. So think about it, when you get insurance for your home from a company like Farm Bureau or something, they insure the real estate, but they also insure the contents or what's in the house or the personal property. And I actually got extra um, an additional piece of insurance to be able to insure some of my jewelry, like my wedding ring and stuff. So that would be personal property. Now, when we think about ownership of property, you think about what is, I said they have these other water rights. There are many sticks in the bundle of sticks. Right now, my mouse is lost. There we go. So the bundle of rights, and that's how our founding fathers thought about property. And it's like a bundle of sticks. So in that picture we saw before, we saw the real estate, but in that picture, there were multiple sticks in the bundles of sticks. And so you have the right to use the property, you have the right to exclude others from your property, you have the right to sell or grant easements. So those easements, like for the power line or for the road or for a ditch easement to get water out of the creek, those are all easements, and those are all sticks in the bundle of sticks. They also have the right to mine for minerals or drill for oil. Now, in Montana, we're a split estate. That means that many of the landowners may not own the mineral rights because the mineral rights could have been split from the land itself. So that is another stick in the bundle of sticks. You have a right to just compensation. If the government or one of the entities that the government has given the right to condemn, that's a private party, condemns your property, you have a right to just compensation. You have a right to lease that property. And there's what also is states in the property. So you could have a life estate, you could have a life, that's the most common one. So I could sell my property to Helen, but I could keep a life estate, which means she will own it when I'm gone because I kept the life estate. Or there's multiple ways you can slice that up. There's another one, it could be an estate for years. We don't use it that often, but those are all nuances of the sticks in the bundle of sticks. Does anything come to mind with that, Helen?
No, not exactly. Maybe just a quick explanation about what an easement actually is. Maybe for
Okay,
those that might not know.
yes, an easement. So a road, and I would say about, I'm just going to leave this slide up instead of go backwards. I would say about a third of my caseload right now are fighting over easements. And so let's talk about roads. They could be multiple different things. An easement is different than a lease. A lease is a contractual right. I could lease a house or rent a house. That's kind of the common way of if you were talking about houses, but I could lease pasture. So it's
Hmm.
usually for a term of years or months, and I pay a certain amount for that lease. An easement is an actual property right because if I give you a road easement or if I give you an easement to put up a power line or a variety of other easements, it's actually created by statute, and you have to, the only easements we allow in Montana have to be created by a statutory definition. In fact, in Montana, you can get a wind, if you're going to put up a wind farm, there is a right to get an easement to be able to put up the turbines to be able to use wind to create energy. However, all the other things you need for the wind farm, such as the surface property, that has to be a lease. So if somebody's going to put up a wind farm, they have to have an easement and a lease agreement. And for that, they would also need the road. So the road easement is allows for a certain width of road and a certain description where it goes. So what happens now is in these rural areas when people sell property, they've been using the road forever because they're friends with their neighbor. So now, neighbor B sells the property and neighbor A no longer likes the neighbors and they bought the property and it doesn't have a written easement. And that you can get a road easement by prescription, which means you use it for a certain amount of time without permission. Then you can establish the right to argue that you've got it by a prescription or you've got it by using it wrongfully for the right number of years. And so but there's all these types of cases you can imagine where we have all the new people coming in and they argue about roads and who has a right and who doesn't have a right. And again, I'd say a third of my caseload is arguing about roads. That's the most common type of easement. But a ditch easement is a right. You don't have to have a legal description for a ditch easement. There's a common law ditch easement to be able to clean your ditch, even if your ditch that runs your irrigation water runs to the neighbors. You have a common law right to go in there and clean it and to maintain it. So
Right.
again, a different type of easement. Did you have an idea about any other type of easement that I haven't mentioned yet, Helen?
Oh, I think that's very helpful. Thank you.
Okay. So now moving on to this is the corner crossing issue. I really don't like talking about this one because it's so hard. It's been a contentious issue at the legislature for at least 10 years. And so what you have here is a map, and this map shows the different sections. All of our land is set up in sections and townships and ranges. And so if you follow this red line and you go through, you see here where it crosses. Um, if you were going to do a corner crossing and that was the issue, and let's say let's say 16 is the public land, like the state trust land or Forest Service land. Usually Forest Service wouldn't be out that far away from the rest of Forest Service. But this is what's called checkerboarded ownership. We're just going to, for this talk right now, we're going to assume that 16 is owned by a governmental entity. And so to get there, they can go, let's say this landowner here, 26, is owned privately, and he gives them permission to go through here, then that would allow them, the argument is they should be able to cross over the corner. Whoops. Now I do have to go backwards. Okay, previous, look at that. Wow, I'm going to get an A plus tonight. So in this has come up as in Montana, we have not yet had the legislature create policy. So right now, the belief is that we do not have corner crossing in Montana. However, just recently, the 10th Circuit, there was a case out of, I think, Wyoming that allowed corner crossing and found that it was legal, and the 10th Circuit upheld it. So that some parties wanted to get the United States Supreme Court to look at that. The United States Supreme Court did not take up the case. So in the 10th Circuit, arguably, you certainly have it when you're by federal land. Arguably, I think there's still a question of if you don't have any federal land issue, if you're just in state court, whether or not there's corner crossing. But there is the issue of the legality there, that it looks like there are some places where corner crossing is allowed pursuant to the law. Now think about it. If you were going to cross over this corner, mathematically, the place where there's a, place where you're doing the corner, where all these corners touch each other, it's a very, very infinitely small point. So the argument is, though, is that if the party is going to cross there, he has to cross the fence, and theoretically, he's not trespassing. There are some trespassing cases that say that if you go through the air over the top of somebody's property, it can be trespassing. So it's very interesting to how to square up corner crossing theories with trespassing theories. And you and you know it'd be very hard to keep all your body parts from being in the private property and possibly in the property where you haven't got permission to use it. So how did this come about? These issues come about because we have lots of federal land and state land that's used for recreation. And that is one of the main purposes of those types of land. But a lot of the federal land actually was not, when it was first federal land, it was not presumed that it was going to actually be continued in federal ownership. Originally, the federal land was supposed to be sold and homesteaded under the Homestead Acts. And the land that's left for what we now have as the Forest Service and the BLM, that's land that wasn't taken, for homesteading. And it was possibly because a lot of the land is in places that it's not as productive for agriculture. And I think a lot of us, a lot of people are happy that we have some land that was left over to be federal land and allow for the recreation uses. But that is, we have a history of how we got here, but they didn't keep easements to the federal land. And we've had lots of litigation, well, not lots, but cases out of Montana in the last 10 years about also seeing if you could get an easement, a road easement to federal land by prescriptive use. So those issues are ongoing, and it's a big thing for people who like to get to the federal lands to be able to use them. I mean, you might have heard about in the Crazy Mountains, there's more checkerboarding there because of a lot of you have to go back and look at actually what act was the land actually homesteaded under. And for some reason, there's a lot more of the railroad lands in the Crazy Mountains. And those were checkerboarded because the railroads were given sections, almost like the school trust land, as part of their deal for putting in the railroads. So in the Crazy Mountains, there's a lot more private ownership than in a lot of places that have remaining Forest Service land. So in there, they've been talking, the landowners have, working with the federal government and a group of stakeholders to see if they can solve that problem and block it up more, and then there would be more access. So there are ways you can, people sometimes litigate and sometimes they try to work together to fix the problem. And that is the ongoing issue about whether the fact that there's even some state school trust land that also doesn't have good access. And so some people, that's why they go to the legislature and try to create corner crossing. Now, if you're a private landowner and you owned all these yellow sections or the white ones, you really don't want people running through your land to be able to get to the federal land. I can tell you right now, I'm talking to you from our ranch near White Sulphur Springs, and it's hunting season, and we do allow hunting on our property. We're full. I'm not saying we have any more ability for people to come, but it is a big deal when you have private land to have people just coming with guns. So private landowners aren't all just being ornery to not allow people on it. I mean, it's kind of scary to think about people running around that you don't know with guns. That's my position. And I support hunting, and I try to find ways for people to be able to utilize their rights on the federal and state lands. So I do have more of a section on easements that I'll talk about next. So, see if I talked about all this yet. So this is a better way to see where all the corners touch. And if private land touches private land, a wall exists. But so here, this would be where they would think that there would be the right to trespass if you had rights from one of these landowners. But then this one here might say, I don't want you to use it. So again, it's a very interesting development to be able to get access to federal and state land that has been put aside for recreation. So easements. This is actually a picture of our ranch where I live with my husband. And usually easements, if you don't have them, you try to get them by hook or crook. I mean, it becomes very important to have easements. The road that you see here is a county road. So that is an easement into the road for the county. Our private road takes off here. Right, there we go. So, whoops. And so the other easements that would be here is, that's probably just the road. There is a creek here. And so there would be, if somebody had um, a water diversion, they would have a right to go to that. They would have, an easement to be able to get to their diversion. But usually this is all private property. So usually the diversions on private property are owned by the landowner. There is a power line up here. So again, that was another easement. I told you that the code defines all the easements that you can have in Montana. So the easements that we have that you can get are a right to pasture, and this is in code 70-17-101, Montana Code annotated. The right to pasture, the right of fishing, the right of taking game. There's a right of way, right of taking water, food, minerals, and other things. Right of transacting business upon the land, right of conducting lawful sports upon the land, right of receiving air, light, or heat from over the land, right of receiving water from land, the right of flooding the land, right of having water flow without disturbance, right of using a wall as a party wall. I have no idea what that means. I think that's from college, I think. I don't know. Right of receiving support from adjacent land, right of having whole boundary fence maintained by one owner. Usually the law about fencing is you go out there and you stand and you look at your neighbor, and each one fences to the right. I think it's the right. And they each are supposed to fence halfway of their common boundary. And so in this case, you could have an easement where one party has to maintain the whole fence. Right of having a public transport stop at your land. Right of a seat in church. I don't think we do that anymore, but the right of burial, the right of conserving open space. So that's what you see when you look at conservation easements. That's an easement. Right of receiving sun, wind for energy generation. And right of using land near a shooting range is a range safety zone. So those are all some of the easements that you can have, but those become a written document describing what the easement is and all the terms. You interpret it like a contract, but you file it like a deed. So an easement is a very specific and a very important document to have if you're looking to be able to use somebody else's property right, and it's in perpetuity. So easements are real property interests like leases, but more durable. They can be in gross. They can be granted to a person. Like you can give someone the right to fish. And that can be, so when it says it's gross, so I give Helen a right to fish for life on my ranch. So that can be an easement that I could give her, and I'd have to write it up, and we would agree to the terms, and then we would file it at the county courthouse, Samar County Courthouse. And so it can be a pertinent, and that means like the road easement is a pertinent. I mean, it's attached to the land. And so that road easement, it is a county road at this point, but if it's not a county road, there are neighbors that live up the road. They could have a written road easement across us. We would file that again, just like a deed. And that would be something that it runs with the property. Do you have any questions right now before I move on to the favorite issue of property rights in Montana, the water rights?
I don't see any questions posted right now.
All right. Well, how did I go backwards? How about next? Well, let me touch on this for a
Oh, I'm
minute.
sorry. Sorry. Oh, yeah. No, we had one, but it looks like you already answered it. So we're good.
Okay. So we did talk about this briefly, but I'll make sure that I covered it. So I told you we have wind easements, we have ditch easements, road, prescriptive. That's where you get it by using it without permission. Written versus implied. So an implied easement, if I develop my property and I cut it up into smaller chunks, it's implied that I gave all, if there's a road that runs through, it's implied that if I owned it in common and there's a road to it, that I gave an easement to where the road goes. And so in a county, and then there's a county road, which I talked about. So water rights. This is one of my favorite issues to talk about. In Montana, it is a real property interest. And so there are 12 to 14 states that use some type of use of the prior appropriation doctrine. And the prior appropriation doctrine is how we've learned to quantify and qualify our property interests in water, use of water. So the states that have more water, those that are to the east, probably kind of if you split America in half, most of the states to the east will have a water rights that has to do with you get to use the water that's if wherever your water runs to your land, you get to use it of what's near you. So you don't have the property interest like we do in the more arid states. Most of the Western states have a prior use doctrine approach. And what is in that is it's a prior appropriation doctrine. So it means the first in time, first in use. So most of our early water rights in Montana are for mining or for agriculture. And the whole theory is that the water gets put to use and whoever has the earliest use filed on it and put it to use, you can't get a property right unless you've actually put it to beneficial use. Then you have, there's not enough water, the people who have the oldest priority date they get to use their water and other people can be shut off. So the other, it's a very common thing to say is that whiskey's for drinking and water's for fighting. That certainly was certain the last few sessions at the legislature. I still do lobby on water rights. And last year, they tried to pass a bill to fix what they call the exempt wells. And so in Montana, since we have the prior appropriation doctrine, most of the water rights have had to be filed on if you're going to have a use in the law in 1973, it had to be stopped there, but you had to file in the 80s. And then we've had to go through decades of proving how much we put to beneficial use and whether our claims are correct at the water course. So some people have spent tens of thousands of dollars to prove up their water right. So all of the water right is a real property interest, but it's not like real property that you can go out and look at it. Like I can say, I can draw out a map, that's my land. I can go out there and walk around the fence. I can show you where it is. Since a water right is a usufructuary right, the attributes of that water are where you divert, how much you use, what do you use it for, the season of use, the priority date. Those are all attributes of the property right. And so exempt wells are wells that are for de minimis use that are not in the prior appropriation doctrine rights. So they wanted, when they put together our legal system and the policy around water rights, I thought if you're going to just use a little bit, like less than 35 gallons per minute for a house or for stock water, then you could use these exempt wells. Well, the way we're doing a lot of development in Montana, because developers don't want to have to hook up, or they may not be able to hook up to municipal water, is they try to put together a whole bunch of exempt wells. An exempt well with 35 gallons per minute is not enough well for, I can't remember exactly how many houses, but not enough for a whole subdivision. So the subdivisions that have been putting in have been trying to put them together. So there's been laws and lawsuits about how and whether that's legal. Recently, the Supreme Court said it's not legal. So they tried to solve what they call the exempt water problem by passing legislation that would have made it legal to use exempt wells for development. Now, I went and argued against that because we have all these people who have prior and senior rights. And so now we're going to let people get water rights without going through the same system and basically jump to the front of the line. I said that the legislation would get water to move to money instead of follow our system of property rights. So the right, whiskey's for drinking, water's for fighting. We fought pretty hard at the legislature, and that legislation did not pass, but it will come up again, I'm sure, in the next session, not this next spring, but the year after. So a water right is a right to use a certain amount of water diverted from a certain place on a certain piece of land for a certain beneficial use. And it has a massive impact on the value of real estate. And if you can't use the water, you've got a dry part of land. In most of Montana, you need a water right to be able to, build or do any type of beneficial use. Now, surely we got a question out of all that controversy.
Nope, I don't see anything right now.
All right, well, I'm fishing for questions.
One question that might be interesting to just touch base on quickly, Hertha, would be whether a water right can be separated from the other property rights and be retained or sold separately when you sell a house or a piece of property, or if the water right runs with the property.
But that's a complicated question. Technically it can be separated. Like if I have a water right and I've been using it for irrigation, I can separate that water right from my property and I can sell it to somebody to use for a development. However, to do that, I've got to, whoever buys it, one of us, the seller or the buyer, has to go through a change application. So
Got it.
any water right is dedicated to a certain place of property. So like let's say, so for irrigation, it has a certain legal description about the field that water right can be used on. If it's a house and a home, that water right that is for domestic use is limited to that home. So if it's going to be changed in the place of use, you have to go to the DNRC and go through the process for a change application. So to change that, I've got to prove that I'm not going to impact anybody else's senior water right. So, and the change has been historically hard, and the legislature, the session before this one, changed the law to make that process more streamlined.
Mm.
And I have not yet gone through it myself to see if that is true. So it can happen, but you can't just say, oh, well, I talked to neighbor A and I'm going to now take his water from his hayfield and put it to use on my land. I mean, that would be a violation of the Water Use Act and illegal water use. So.
Mm-hmm. We did get one a question that was posted. If it's not addressed on the upcoming slides, can we touch on when natural needs become a right that has legal standing? So, for example, water and streams for fish, natural habitat survival, or groundwater recharge.
In Montana, they were very thoughtful several decades ago, and they actually allowed in-stream flow rights as a right that competes in this system. So
Mm-hmm.
there are rights for fish and in-stream flow rights. So that is a way to put a natural right into the system of property rights. Otherwise, let's say, like even this last summer, we had probably some of the worst issues with temperature. Even though we had a less than average year for rain flow and moisture, for some reason we had some of the lowest stream flows ever. And we do allow a very small amount of fishing, so we're very aware of trying to take care of the health of the stream. And we don't allow fishing at a certain point, so we're aware of what's happening there. So, but beyond the landowner taking care of it, there is no quote natural right unless that natural right has been quantified by purchasing the in-stream flow rights. So there are environmental groups and the Montana Fish and Wildlife Service, I think that both own those environmental groups and the state own water rights for in-stream flow rights. So otherwise, for natural rights, they'd have to go through that system. They can also purchase water rights. I mean, there's oftentimes, a lot of the market has worked mostly in Montana. We do have, quote, a free market for water rights, but most of that market has been utilized by Trout Unlimited to buy water in streams that are at risk for fisheries that are potentially endangered, and they've purchased or leased a lot of water to be able to protect those stream reaches. So that would be a place where a group has used money and the free market to be able to purchase those rights from willing buyers, willing sellers. And to my knowledge, that system has worked pretty good. I know it's the best if to do that, you also have to go through a change application. And if the people who work for Trout Unlimited are very good at what they do. And so it's a very good way to get your water rights trued up because what they buy, they have to prove that it is what you say it is, that it has been put to beneficial use, that it's not overclaimed, that it's not, you have to make sure that what's on the paper is actually a valid wet water right, which means,
Mhm.
it's very hard to explain, but the water rights that have been filed on, so somebody filed in 1888 and he said, I have 800 cows and I use it for this. Well, that may not have happened then and it might not have happened since then. So for a water right to stay valid, it has to be put to beneficial use and it can't be abandoned. And you have to be pretty exact in all the attributes because of the enforcement system.
Got it. Thanks.
So the next thing we're going to talk about is mineral rights. Now this one's easy. What you see here is, somebody, digging for gravel. And note that you just because you own the surface doesn't mean you own everything that's underneath the surface. You have rock and dirt are not minerals. So those, you know, arguably the landowner owns that. However, you get what oil and gas, that's subsurface, and that can be split estate and it can be owned by, an oil and gas company. And then there's coal, rights, which is also can be a split estate. Like a lot of the property that we have where we ranch, the a lot of it's been in his family since before Montana was a state. So since then, you can think about that. He's fifth generation, I think. So since then, the property's come down, and it's been split out. It's all still in his cousins. None of the property has gone out of the family since then. However, the mineral rights were split amongst the broader group. It didn't go with the land. So, you can be pretty sure that most of the mineral rights probably belong to remnants, cousins of the family. But there aren't really any valuable minerals that we know about. So nobody's really gone to try to check who owns the mineral rights because it would have been, so let's say that John's his grandpa's brother pass it on to his children and they pass it on to their children, the mineral rights. So all of a sudden it's pretty hard to try to figure out where all those went and hopefully everything got filed at the courthouse. Somebody wanted me to look into that once and I decided that wasn't my area of work because you have to sit in the courthouse and literally try to track all this down. And it normally doesn't get done unless they find something of value, a mineral right that's of value. So another, there can be metals and gems. I would like to own the Yogo mine in, near Lewistown. That'd be a pretty good mineral right to have. And I don't think they're mining right now, which means if you have any Yogo stones, it's worth a lot. And of course, we also have the sapphires, the Montana sapphires over by Phillipsburg. So that would be, in that circumstance, I don't know the status of that mine, whether that ever got severed or whether it's owned by the surface owner, but that would have been a good one to hold together. And don't ask me about the other issue, which we did put, fossils are not minerals. So I think that means that fossils go with the surface owner because the minerals are what can be severed. And so if they find a big T-Rex on your property, they had a big case that went on and on for a long time to figure out who owned the fossil, whether it was the person who owned the mineral rights or the person who owned the surface. And based on my handout, and this is something I always can't ever remember for sure, but I think that the fossils are not minerals, so that means it goes with the surface estate. Eminent domain. So eminent domain is when the like I have a case right now in Missoula where they're trying to widen one of the streets, and they're going to have to take. I have two landowners. There will be a total taking of their house and everything. And the state of Montana has a right to take property to widen the road. But to do that, pursuant to the Montana and the United States Constitution, the United States Constitution says, nor shall private property be taken for public use without just compensation. So according to the United States Constitution, it has to be a public use. Pretty easy to understand that widening the highway is a public use and for just compensation. And the Montana Constitution is a little bit different, similar in concept that private property should not be taken or damaged for a public use without the just compensation to the full extent of the loss having first been made, which in Montana, they actually pay attorney's fees per the Constitution. If they take the landowner's property and the landowner has to fight them and the landowner wins, then they have to pay their fees as well. That doesn't happen in all the states. So one of my first cases, when I told you about that I covered as a journalist, was Lucas versus South Carolina. And that was a case where South Carolina decided that they wanted to protect the beach because it was eroding. And so they didn't allow somebody, I don't remember what their setback was, but they wouldn't allow them to build. And that went all the way up to the United States Supreme Court. And the Supreme Court, said that unless they take 100% use, that it would be a taking when it takes all the uses. So they sent it back down to the South Carolina court. And they then, in that process, they ended up selling. The state paid for the property and then they sold it for development. So it's a very interesting case about takings that they wanted to protect it until they owned it. And another case I have right now is a pipeline in eastern Montana, and the pipeline is put in and it was carrying crude oil. But now they want to put some type of, I think, NLG or some type of other liquefied gas or something. And that's not in their easement. That's not in their written document for what they condemned it for. So now they want to condemn it for a different use. And we're arguing, I'm arguing on behalf of landowners that to be able to condemn property, if you're not the state, you have to be given a grant to be able to take it for that. You like, I can't just go take my neighbor's property because I want to. And so a company, one of the first cases I ever did in Montana was called Maddle, and they were trying to put a power line into Canada, and they were taking a whole line of private property all the way up there. And I argued that it was a taking, and I actually won at the district court. And then they went to the legislature and got legislation saying that that type of power line would have the right to condemn. It was a private entity, so private entities can condemn property for in certain circumstances. But that grant to be able to use the huge hammer of eminent domain, you have to specifically interpret the law because that's such a huge hammer. It's, you can't just allow companies to take other people's property so that they can build their businesses. And so this company, that the pipeline, I'm arguing that they don't have the right for eminent domain for this type of use, the gas, because it's not in their statutes. And even if they did, they'll have to prove that it's a public use. So in this circumstance, they're piping gas through Montana from another state to another state, but that none of that ever gets to be a beneficial use in Montana. So no Montanan, so the public use in Montana is supposed to be about a public use for us, not for some company making money as it goes through the state. So that'll be interesting to see what happens there. And all you get paid, though, some people like, they violated my rights. They can't do that. And I'm like, no, If they've proved if it's a state entity and they've proven it's a public use, then they just have to pay just compensation. And just compensation is the value of the property based on appraisals. So, you do get paid, but I guarantee you that these cases are some of the hardest I've ever done. I didn't want to do divorce law. I guarantee you that most people, when they're sued for eminent domain, they did not want a divorce from their land. And so they're very upset. One of the people I'm representing in Missoula, it's a family home, and it has been in their family for more than one generation. So that's heartbreaking to them that the state can take their home, even if they get paid just compensation and they actually are able to find another home. They still didn't want to leave this home. So eminent domain is hard, and it's and it happens, and it is the area that I don't know, I'd say a third, a half of, maybe a quarter of my um, workload is eminent domain on behalf of landowners. So I already went over this, the public uses. There's a Montana code that specifically defines what the public uses can be. And the taking cannot benefit a private person or an entity. And the case law in Montana is very clear about that. So it has to benefit, the public, which I'm not sure how this pipeline is going to prove that either. And it has to be at fair market value, and it usually involves litigation. Covenants. Oh, they asked me to talk about homeowners associations. I want you to know that is one area of property law that I don't regularly practice in because it is so, I mean, it's like divorce law. You know, you don't like what your neighbors are doing and they did this and they violated this. And so, but covenants they're not quite, they're more than a lease, but less than an easement. So when I'm in Bozeman at my law practice, I live in a condo and we have covenants. And so the covenants are restrictions on land use. They're in writing. It runs with the land and it's interpreted as a contract. And so by that, it's it's very specific about what you can and can't do. And if there's an ambiguity, it will be decided in favor of the free use of the property. That's a standard of law that has been upheld by case law. And one thing recently is short-term rentals have been defined as commercial uses. Really quickly, I have one case now that has to do with covenants in Gallatin County, and it's about my client's neighbor wants to put up a commercial hen laying operation. I don't know, more than 500, I can't remember how many hens, but a lot of hens, and raise eggs. And they're arguing, and so they have covenants on that land that says no commercial use. And the neighbor is arguing that it's not commercial, it's just chickens. And anyhow, I'm not sure how that's going to turn out, but we're arguing it is commercial and it violates the covenants. And it's not agricultural because chickens are not actually defined. It's agricultural, but it's not livestock. Chickens aren't livestock according to most of the laws in Montana. So that's kind of a fun one. And I know the law clerk, it's actual litigation. The law clerk likes it because she says it's more fun than a lot of our other cases to argue about chickens and hens and what they can and can't do. So we're almost done. We're to questions now. I hope there are a few questions, Helen.
No new questions have been posted. But I would encourage anyone to, if you have any, to post them.
Did any questions come to your mind?
We have someone who raised a hand. If you could go ahead and type the question in the.
I'd answer one if you can put them on.
I'm
happy with that.
It seems like I can do that. Maybe.
Wonder if our state. They might have to type it out.
Yeah, I think if you can type it out, that would be great.
So recently, we've had a lot of activity at the Supreme Court on covenants. And again, most covenants do prohibit commercial businesses. And as I said, we're one of the few states that define short-term rentals as commercial business. And I'm very interested in that topic because when does I mean, you can rent your house. So what does short term have to do? I mean, it seems to be we're kind of encroaching upon property rights.
Right.
But a covenant by its name is an encroachment upon a property right. When you bought that property, you agreed to the restrictions that were on it because most of us who have belong to homeowners associations that have covenants, we bought the property knowing that those were there. Otherwise, we would have had been part of the process to create them. All right, Helen.
Yeah, I was going to ask, are there other issues right now, Hertha, that you see popping up in your practice, maybe over the last year or two, that you're really seeing property owners struggle with? I know you mentioned corner crossing. That's been a big one for the last couple of years and has had significant activity. Are there other issues you can think of that are at the top of mind right now, especially after the last legislative session?
Well, just recently, and this doesn't come from legislation, but zoning. Zoning is still a hard issue for Montana, and there's a some counties have provisions where neighbors, citizens can zone. It's called a citizen zoning process. And recently, over in Park County, some citizens got together, and they owned kind of smaller parcels, and they included what a neighbor's parcel who's 200 acres in their zoning, and that party did not want to be included. And it just so happens that we were, you, my client argues that they didn't follow. You have to go through the process. Again, it's a property rights issue, so you have to follow the process, the recipe exactly. Because if you don't give notice, you don't give people a property to be, opportunity to be heard, you don't do exactly how you're supposed to, then the process, you can be overturned based on the process. But we also argued it was a takings because they've taken, my clients have all this open ground. Now they don't necessarily want to develop it, but they don't want to lose the rights to develop it because that impacts their value. So you live on a 10 acre or 5 acre lot, and you do this, you get all your neighbors that don't own the, don't have very much land, you guys get together, but you gobble up some of the other ones. So basically you've turned them into your open space or your wilderness through citizen zoning. And I haven't checked it out yet, but the people who've joined this, that created this zoning district, if they have covenants, they may not have given up any rights in zoning. They just, pushed their covenants or their desire for property based on this other land that they put into their zoning
Hmm.
area. So that's kind of interesting. I had no idea until I got it really looked at this case that this could happen pursuant to Montana law.
Hmm.
And there's more discussion right now about stream side setbacks. And I've had some cities that were looking at that. And if they take it without paying for it, it is a litigation. It is a possibility that they've taken somebody's property rights.
Hmm.
Sandro Day O'Connor, in one of the biggest cases on taking, said, you know, if the government takes it for a public use, in all fairness, according to the Constitution, they have to pay for it. So you can take it, but you have to pay for it. And that's the fair market value for what they take. So if it's only 10 feet, getting paying for 10 feet is, not that much if you took 200 feet. So
Right. And there is a question here sort of related to that, about whether eminent domain could be used on the same parcel potentially more than once.
yes, because if they don't take all of it and there's some left, yeah, they can come back. I had an interesting case here in Bozeman, and there was a rest area that was taken years ago and it was litigated. And that was about whether or not it was for a private use or a public use. And when they got it, they had to, if you take it for eminent domain, you have to keep it in public use. Like, let's say the city of Bozeman takes land for something and then they decide they want to sell it later. That's a violation of how they being able to use eminent domain to take it in the first place. So, you know, you that's a place where they did take it, but then they violated their how they took it. And so, the previous landowner was able to come in to kind of cry foul that they violated their agreement and with the use of how they got the property in the first place. But if your land is by a major highway, they can keep on widening the highway and just keep on taking more and more. And at some point, it depends on how much they take, but if you can't get into your house anymore, or if it's too close to the road, then they would have to pay you 100, for total, diminution of value for your home. There's also something for people who lose their business.
Mm.
They can be, there's a law that federal law that if they use federal funds for the road widening, then they have to follow this federal law that requires them to put the business, give them enough money to be put to rebuild or buy another place that's similar. So there are relocation expenses, and there are also some available for landowners. So there, it is, they try to keep it fair. And every time I get involved, they never offer as much money as what it's worth. And, the if you ever face eminent domain, you're better off hiring counsel, because one of the attorneys that did a lot of work in this before me, kept tally, and he said that you get paid at least twice as much. The state is trying to do a good job of not paying a lot of the state's money for land. And so once an attorney's involved, they usually offer more. And I've only litigated a few cases, which I won, and then the state had to pay my fees. I loved that. So
And then I think we have time maybe for one last question here, which was just to follow up on what's the status of Airbnb or those types of rentals. Have courts ruled whether municipalities can limit property owners' ability to short-term rent?
I know that covenants, that is one way to limit them. I have not yet looked into, I just got recently, somebody asked me that question to look into it for them, a property owner. And that really has piqued my interest, because covenants, again, if you bought it with that covenant, then you're, in no commercial business. That's a little bit harder to argue against. But if you don't have covenants and the city just regulates that very well may be a taking. And what I told the person who asked me to look is, I belong to a group of landowner attorneys. They have one in each state in the United States. I'm the Montana rep. And I was going to go out to my group of colleagues and ask them what other states have done with the short-term rental bans, to see whether or not that has been upheld as a taking of private property rights. Seems to me that it's getting pretty close.
Okay. Well, I think that's about our time. I just want to again thank you, Hertha, for doing this. You've been such a committed participant to this program, and we just really appreciate you taking the time out of your day to present to us tonight and answer questions. And I'm sure it was incredibly helpful for everyone. I also want to remind folks that there's another session next Wednesday, I believe, actually November 12th, with Amy Hall about Montana landlord tenant law. So if you're interested in that topic, would encourage you to weigh in, join us on November 12th. With that, I think that probably concludes the session. And just again, thanks, Hertha.
Thank you so much. It's been a pleasure to be with you, and nice to see you again, Helen.
All
And I want
right.
to thank the State Bar for giving me the opportunity, and for providing this opportunity for people to learn about the law, since it affects all of us each day.
Right. Thank you.